We'll try and follow as closely as possible the time limitations, but we want to give you an opportunity to get your thought across.
Gradually but steadily over the past 35 years, more and more decisions have been taken out of the hands of the American people and vested in courts. Those preoccupied with the merits or demerits of the specific issues raised in the cases involved pay little attention to the general drift away from accountable representative government. The ad hoc way many of these landmark cases of this era were based on legal principles improvised for the moment has meant that law itself has become more and more a matter of how judges happen to feel politically or socially about particular issues or particular litigants. No one has opposed these judicial trends more consistently or more ably than Robert H. Bork, first as a scholar and then as a judge. Mr. Bork has rejected the idea that judges should engage in heroic adventures in policymaking, as he calls it. The renunciation of power, he has said, is the morality of the jurist, not the assumption of power in the name of morality. What Mr. Bork has fought against consistently over the years has been, in his words, government by judges who are not applying the Constitution. Against this background of historic issues about the very meaning of law, it is both ironic and appalling that Judge Bork's own record is being judged on a myopic basis of an issue-by-issue statistical box score on how he has allegedly voted for or against one class of litigants or another, as if he liked chemical companies more than he liked pregnant women, or liked asbestos manufacturers better than he liked bereaved widows. Surely no responsible person thinks that this is what law is all about. Yet such shrill propaganda from special interest groups is repeated in respectable quarters as if the statistics represented some objective fact. Many people have no idea how utterly worthless and therefore deceptive such statistical box scores can be. Last year this time in California, there was a bitter election campaign over the re-election of the state Chief Justice. During that campaign, one side cited statistics to show that the Chief Justice had voted for defendants 85% of the time over a period of nearly a decade. The other side, using exactly the same raw statistical data for exactly the same span of years, concluded that the Chief Justice had voted for the prosecution nearly 90% of the time. Well, these are not small differences, either in terms of numbers or implications. Neither were they based on any esoteric statistical methods. All that they depended upon were differences in definition as to what was a vote for the prosecution. The statistics thrown around recklessly as to how Judge Bork has allegedly voted against women X% of the time or for some other class of litigants Y% of the time are no more reliable than the definitions used by the special interest sources from which they come. Arbitrary definitions are no less arbitrary when they are expressed in numbers rather than words. Taking these box scores seriously reflects either a dangerously naive gullibility about statistics or an even more dangerously cynical view of the truth. The same kind of box score approach has been used against Judge Bork in the racial area, except that all the things Mr. Bork has done to advance the civil rights of blacks and Asians are either ignored or played down, while every legal question he has raised about any portion of any civil rights law or court decision has been automatically defined by his critics as being anti-civil rights or anti-black. Obviously, I wouldn't be here if I believed any of that. The landmark civil rights cases which Robert Bork initiated or joined as Solicitor General have been dismissed by his critics because supposedly he was only the mouthpiece of the administration. But surely no one believes that someone with Robert Bork's marketable skills was so desperate that he had to hang on to a job that required him to perform duties which conflicted fundamentally with what he believed and wanted to do. Civil rights need to be understood not simply as a special benefit to minorities, but as something essential to everyone. Civil rights define a civilized and humane society. State-imposed discrimination was central to the racial oppression of blacks during the Jim Crow era in the South. Judge Bork opposed this central focus of racial discrimination, from Brown v. Board in the 1950s to Washington v. Davis in the 1970s to his work on the Court of Appeals in the 1980s. His criticisms of particular parts of particular laws and court decisions have often been in terms of the extension of constitutional rules from the government to private individuals and non-governmental organizations. These serious legal questions are by no means confined to Judge Bork. The law journals and law books have been full of controversies for decades over so-called state action. It was precisely this principle which many raised in the restrictive covenant cases, which are not simply cases about whether you are for or against housing discrimination. Demagoguery on this point is especially uncalled for, since no one, as far as I've been able to tell, has ever seriously advanced any evidence that Shelley v. Kramer or Reitman versus Mulkey made any discernible difference in racial housing patterns. The question is whether political symbolism was enough reason to justify trying to make the Constitution say something that it did not say. In our preoccupation with specific issues and specific groups, it is easy to forget that all groups stand to lose as Americans when the law is undermined as judicial activism surrounds all laws with a large and growing penumbra of uncertainty. Education in many public schools becomes impossible when the uncertainties of the law make expulsion of disruptive students difficult, costly, or a time-consuming ordeal. Yeah.
You want to summarize your
I think I have 10 minutes, was it? I have about a minute, another minute.
Fine.
No one loses more than the black community when their children are not educated or when judicial undermining of law enforcement makes their streets far more unsafe than they were 40 years ago. Legal principles are not just abstract intellectual matters. They are often far more important to far more people than the specific issues which provoke single-issue organizations to venom and propaganda. If more people will look beyond this propaganda to the enduring principles which should guide the law of the nation, I am sure that more will support the nomination of Robert Bork to the Supreme Court. Thank you.
Senator Hatch. You're widely published, you've lectured widely, you've appeared before many congressional committees, certainly before committees that I've sat on, and you're widely respected, I think, by people from all types of persuasions, and you've been a principal spokesman in many ways for ethnic America. We've repeatedly heard from leaders of the civil rights groups that judicial activism is beneficial to minorities. Now, do you agree with this? And why do you think that civil rights leaders in this country, or at least the top leaders of the civil rights groups, are so opposed to Judge Bork?
I don't believe that judicial activism has been beneficial to minorities.
Speak in the machine.
Yes.
You need to pull that up just a little bit and get it close to you.
All right. I don't think that judicial activism has been beneficial to minorities. One of the reasons is what I've mentioned earlier, that it's extremely hard for kids in many ghettos to get a decent education today. Let's say as decent an education as I got in the center of Harlem 40 years ago, because the disruption is so much greater today and there's so little you can do about it. If you expel more black males from some schools than you expel Asian females, that becomes a court case. You have the American Civil Liberties Union intervening in these places. There were students, there were parents actually, parading, I believe in Chicago, with signs saying American Civil Liberties Union keep out, because they wanted their kids to get educated. That couldn't be done if you're going to have to due process every disruptive student. So I think that's been very harmful. I've seen the deterioration in crime as well. No, I don't believe that judicial activism has been beneficial to minorities.
Over the past few weeks, we've witnessed a great irony. Judge Bork states, and continually states, and has written that he believes that the people's elected representatives should determine policy in this country, not unelected, lifetime appointed judges. Yet some of those elected representatives are objecting to this nominee who contends that Congress, not the courts, should make our fundamental policy choices. Now, why do you believe that some members of this body and others who are liberal in persuasion are worried about a judge who will really let them make the nation's key decisions?
Because they will have to make those decisions publicly and stand up and vote, whereas judges can simply engage in verbal sleight of hand about constitutional clauses and make the same decisions.
I think that kind of sums it up.